What this case demonstrates is that the Roberts Court doesn't always get what it wants. This was a 5-4 decision going the other way, with Justice Kennedy joined by the more liberal justices on the court, affirming the Ninth Circuit and sustaining the constitutionality of a public law school's policy, saying that any group of students that wants to join and become a school-recognized and school-funded group is free to do so at our school, but you have to admit all comers. And in this case was brought by a Christian legal group, the Christian Legal Society, that believed that that open membership requirement infringed its free speech and free exercise rights.
The question of whether or not they're protected under either a speech or a religion analysis should not depend upon whether or not we, as wiser and more sage individuals than them, believe that they are right or wrong in what they believe.
Hastings doesn't care why you exclude one of the individuals that on the basis, if you're excluding the person on the basis of homosexuality or religion or veteran status or race, they don't care what leads you to that conclusion. The fact that the organization has a viewpoint objection to the anti-discrimination law does not make the anti-discrimination law itself anti-viewpoint.
And what it did so is under one of two policies, and there was a useless political wrangle as to whether this was done under a take-all-comers policy, which would apply not only to religious groups but to every group, or under a narrower anti-discrimination policy, which says that organizations involved in this particular institution had to agree not to discriminate on the grounds of sexual orientation, which surely this organization did. And this is my basic reaction. I have never heard of a stupider, less coherent, and indefensible property than a take-all-comers policy with respect to organizations that maintain any form of intellectual coherence. Justice Scalia said it was weird that the Democrats have to admit the Republicans, that it turns out that Christians have to admit Jews into their organizations, or vice versa. There is no question that if we were to look at this as a form of direct government, the idea that the United States could, by statute, make every private voluntary organization into a common carrier, which had to take all of the traffic, when in fact that the whole purpose for meeting together is to form common coalitions, seems to me to be nothing short than a banal absurdity in the way in which we would want to organize society.
And looking at the history of the all-comers policy, actually, if you go back centuries into Old England, you think of the sort of Scottish innkeeper, it was the case that the innkeepers were supposed to admit all comers. So this wasn't something that was sort of concocted up by a law school in San Francisco. There actually is an ages-old historical basis for that, although more recently discrimination laws have gone in a different direction. The other thing that I would mention, and I don't want to upset Richard too much because I can see he's visibly upset here, is that, look, this was a case about what a law school could do in the context of a limited public forum that has particular First Amendment rules that the Supreme Court has long applied. And the Supreme Court's decision is very much focused on the standpoint of how do we analyze this from the perspective of a limited public forum in the law school itself, which is trying to create an environment in which all students are paying for a particular forum, the extracurricular activities undertaken by these groups, and the divisiveness that could arise if some students who were paying for it weren't permitted to join groups that they wanted to join. And the school in this context decided that the best way to go about this was to have a policy that said all groups that want to participate in the school-funded forum should admit all comers, and the court held that was unconstitutional.
Every single rule in the early cases that talked about the common carrier situation also understood and applied that limitation, without exception. If you want to go through it, the most definitive statement is an Allnut in Inglis in 1810 in England, where they said common carrier rules apply with respect to all comers, where you have to supply with reasonable rates, but in those situations where you don't have a natural or a legal monopoly, the appropriate rule is freedom of association. And I mean, to sort of take this history in the first part and then to ignore the second part is to simply engage in this kind of law office history which doesn't go back and try to get the essentials with respect to the problem. And the third point is that the point is sure that the view isn't viewpoint by the state, although God knows what their motivations are, but the impacts are differential, and the question is, as Todd A. said, whether or not when there are disparate impacts of a really pronounced variety, ought we to ignore those things. And I think that to the extent that First Amendment law has been good, it has not been indifferent with respect to these effects, and to the extent that it does ignore them, it's very dangerous. And again, Greg, I'm going to put the question to you. Do you think we could pass a statute which says that every religious organization has to admit all comers regardless of their religious beliefs, and that that would be constitutional for the free exercise of religion? You have to say yes in what you say, and I don't believe that you believe it.